All right, everyone. Good morning and welcome to Alphabet Soup, How to Make Sense of HR Compliance. My name is Rena Saltzman, and I'm going to be your host for today's webinar. Before we get started, I'm going to go over a couple of housekeeping items. This webinar qualifies for SHRM and HRCI recertification credits, and we'll be providing those activity IDs for those credits at the end of this webinar. In addition, if you have any questions, please add your questions to the Q&A function that's at the bottom of your screen. We'll try our best to get to your questions if time allows. And if we don't get to your questions, please note that we'll try our best to follow up after the webinar to make sure that we get those answered for you. This presentation and recording will be available, and we will be sending it to you in a follow-up email. So make sure that you guys are looking at your inbox this week because we will be sending it directly to you through email. In addition, we'll also have some additional materials that you guys can have access to that will help benefit your organization. Now for the fun part, I have the privilege to introduce our speaker, Elizabeth Williams. Elizabeth is a principal at Rehmann, and she also leads Rehmann's Human Resource Solutions division. As a strategist, thought leader, Elizabeth collaborates with Rehmann leaders, drives growth for our HR solutions practice. She leads Rehmann's team of consultants, and she impacts her clients' organizations through progressive human capital strategies. Elizabeth, we are so thankful to spend time with you this morning as you help us make sense of HR compliance. Let's get started.
Thank you, Rena. Well, I'm excited to share some stories with you today and walk you through some of the hot buttons of compliance, some recent laws that have been enacted, as well as some new laws on the horizon that may be enacted. So let's get started. The focus of today is to help educate business leaders and share our insights for laws and regulations, give you some best practices that govern the employee life cycle from recruitment to offboarding, so you can better navigate what HR compliance is all about, and ultimately to help you mitigate risk. We'll cover new and proposed legal updates about changes in the law, regulations, and raise awareness, correction, and prevention of compliance risks. So what do all these acronyms stand for? ADA, COBRA, ERISA, FLSA, OSHA, DOL, and the list goes on and on and on. We speak in acronyms in HR. HR itself is an acronym, and I love it. I love it. It's a craft and a science and an art, and I'm very excited to share some stories and insight with you. So let's get started first with about new laws that have been enacted. If you weren't already aware, the Elliott-Larsen Civil Rights Act has been amended in March. Governor Whitmer signed to add these protected additional classes under sexual orientation, gender identity, and gender expression. Now, we already have the federal law, Title VII of Civil Rights, that covers, prohibits sex discrimination, including sexual orientation and transgender status. But what this means is Title VII applies to employers with 15 or more employees, but under Elliott-Larsen, it applies to employers in Michigan with 1 or more employees. So that's the shade of difference. So employers should consider whether you need to make updates to your internal policies and employee handbooks, and also any manager trainings to expand awareness of this. As you may have also heard in March, the right to work law was repealed. What does this mean? Well, what it meant was, when it was in place, is that in unionized shops, employees could opt out of paying union dues. Well, now that it's been repealed, if you have a unionized shop, check your CBAs, your collective bargaining agreements, another acronym, to see if you have any language that's in there that says, should this right to work law be repealed, then those dues for deduction from payroll automatically have to be turned back on. If it's not in there, then actually the date to enact that would be March of 24. So they're giving a full year before the repeal becomes in effect. But what does this mean for union and non-union workforces? Well, it's possible that union members who don't want to pay dues may move to decertify from having a union. It's possible. And it's also possible that activity to organize and form unions may increase, which is likely more possible. So what I recommend is if you have a non-union workforce that you would like to keep non-union, pay attention to your workforce and assess your organization's work conditions, wages, benefits, and equitable treatment so you can uphold the best possible offerings that you can provide to your employees. Now, we have two additional laws coming up. The PUMP Act. This impacts employers with 50 or more employees compared to the Pregnant Workers Fairness Act, which applies to employers with 15 or more employees. And so we've already had the Nursing Mothers Act in place, and this expands it to require all nursing mothers must be provided a private space, which has been already in the law, and specific break times to express breast milk. The prior law only allowed for coverage for employees covered by overtime, hourly employees under the FLSA, but now it extends to salaried exempt employees as well. So that's the shade of difference. And the other act, the PWFA, as I said, 15 or more employees, starts in June. So this is looking prospectively forward here. And employers are required to grant reasonable accommodations for pregnant workers and applicants, and of course prohibits discrimination against them because if they need an accommodation. The most important thing here to point out is the ADA's interactive process, and we'll go into more detail about what that is, but it's basically asking someone, what do you need in order to do your job? How can we accommodate you? And determining as a company if it is reasonable. So impacted employers, you may want to review your policies and accommodation processes. How do you go into that interactive process? And do you have the space for your nursing workers so you can be compliant within this legislation? Now, I want to talk about some examples of the EEOC and DOL. Equal Opportunity, the Equal Employment Opportunity Commission, and the Department of Labor. There has been an uprise of claims. And to explain the difference here under EEOC, we have the federal Title VII, all the protected classes there that you can see. But did you know that Michigan has additional protected classes above and beyond that? Height, weight, sexual orientation, gender expression, misdemeanor arrest records, not to discriminate against people who have that, applicants, and marital status, family status. So it is prohibiting if someone making light of someone's too heavy, someone's too skinny. If they're putting it upon someone who's single, for instance, and doesn't have a family, well, you need to work in the office more, as opposed to someone, well, they have a family, so let them work remote. That's how you can create discrimination and inequitable treatment. So those are some examples there. FLSA wage and hour audits are on the rise. Fair Labor Standards Act. The DOL have added over 100 new auditors. And what does that mean? There's more workers to take on more cases. Now, the appropriations to the payroll fraud unit, this unit has been granted in Michigan more money to hire more employees just in Michigan. The equivalent of 25 new employees to go out there and investigate misclassifications under FLSA. So this is what we're going to dig into. Why does the DOL send you a nice little letter saying we'd like to pay you a visit? Well, it's not luck of the draw. It's not random. Typically, something is tipping it off. It could be a disgruntled former or current employee or an independent contractor who thinks that I should be getting benefits and I should be getting overtime. Why aren't I? We're going to talk about ICs, independent contractors, as well. It could be that they have an alleged wage complaint, or they feel that their rights are violated. I had one client years ago who they didn't know about the Nursing Mothers Act, and they had someone who was a server who needed breaks, and the manager said, "What do you mean? You got to work. You can't take a break," because they did not know, and the DOL came knocking. Maybe your competitor has contacted the DOL. That has happened, because that's, that can happen. Maybe they're cracking down on an industry in particular. Typically, it's manufacturing-based hourly jobs, but again, it's rarely luck of the draw selection. And what we're seeing is general potential issues is overtime pay isn't being paid correctly, misclassification as independent contractor versus employee, or maybe they feel their rights have been violated. Those are typically the reasons why. This is a snippet of an actual demand letter that I just received from a client just yesterday. No names, just one of the things. This is what they're asking for if you get a demand letter. They ask you for 2 years of back payroll records, a full census of your employees, including how to contact them so they can have freedom to contact whoever they wish, which by law they can, and ask them any questions that they feel they need to, which by law they can. And they're going to ask for your timesheets, and also if you have any minors, because they're also cracking down in that area. We had another client recently who didn't know about the underage laws of what an employee could and couldn't do under the age of 18 operating heavy machinery or any type of equipment that could be dangerous, right? Heavy machinery or not. And they got assessed some pretty hefty fines, unfortunately. So what do you do when you get one of these letters? First thing, don't panic, breathe, get HR involved immediately. And your HR team may not have experienced something like this before, or maybe you don't have an HR person. You have Rehmann as your next line of defense. Contact your business advisor. If you have an employment attorney, yes, get them on the phone. If you do not, we partner with them so we can work in tandem to get in front of this. Like I said, I've had two in the past week, and then one in prior. So we've been dealing with these. Here's what you may not know. When you get that letter, they say, we're going to come next Tuesday. So have all your records ready, and we're going to sit down and we're going to talk. And we want to talk to some of your employees. That does not give you much time to go through all of that. That's why you need to reach out to Rehmann and your employment attorney. You can ask for a postponement on that visit. They may say we're going to be there, but you can say, oh, I need more time. Can we please bump it out, up to 3-4 weeks out? And they will grant that. They don't tell you that, but they need to abide by that. And working with a third party, such as Rehmann and your employment attorney, this will help create efficiencies and assured cooperation with the DOL auditor. They're very used to working with third parties, and it actually makes them feel better, believe it or not, that, oh, this company, they want to do the right thing. They're contracting with outside legal help to make it go smoothly. They actually look at it as a positive thing, and it does go smoothly. And we can help navigate, especially if you have, for instance, more than one company. Some business owners have more than one. What the DOL wants to do is, even though they send you a letter for one company, for one thing, once they hear that you have all of these other companies, perhaps, they're going to want to pull all that data as well and see what they can find. And whole new cans of worms get opened. So having the proper support through a third party, we can help keep them focused where they originally started. Remote workers and wage and hour issues. So this is a heads up on this. If you have a company in multiple states with remote workers, keep in mind different minimum wages can apply, and state laws can vary when it comes to overtime pay obligations. So like California, for instance. So make sure that you are checking that. Payroll and employment law requirements can also vary by state. Let's dig into the employee life cycle here. So from recruitment, when they're not even an employee yet, all the way through separation. These are some compliance issues that I want to walk through as much as we can here without getting into the nitty-gritty of every form, but I want to give you some highlights here. Firstly, do you have an EEO statement on your job postings and on your application? Whether that is an electronic application or the old-fashioned paper, if you still have one of those, make sure you have this disclaimer on it that shows the company's stance on being an equal employment employer. And then I took a snippet here of the EEO guidelines for interview questions, what you can ask, what you shouldn't ask. So this is just a snippet. I have a full, I think it's 3 pages long, that you can request, and I'll be happy to send this out as one of our tools that you can use. But for instance, you don't ask what their age is. You ask, are you over the age of 18? That you can ask on an application. What's your availability? Do you have daycare needs? You can't ask that. Oh, do you go to church on Sunday? Because you may have to work on Sunday. You just ask. This job requires hours to work on Sunday. Are you able to work on a Sunday? Not whether or not they have a church service to go to or daycare and so forth. So this is a handy list that I'll be happy to share with you. Hiring. How do you stay compliant when you're hiring? Well, firstly, you picked your candidate, and now we're going to talk about what are some best practices and some compliance pitfalls to avoid. Make sure you have a solid, well-crafted offer letter, that it has everything that it needs to be in there, but that it's not a contract. And make sure it has an at-will clause, that an employer or an employer can end it's an at-will relationship. It can end at any time for any reason by either party, with or without notice. So something like that. Determine if an employment agreement is necessary and if it's enforceable, such as a non-compete clause. And we're going to talk about that. That's a pending law that may be changing. Here's the thing. Not all jobs really require an employment agreement or a non-compete. I can see in some industries, some jobs, as in sales or proprietary professional positions, does a receptionist, does an administrative assistant? Not necessarily. I was with a company once who gave it employment agreements to every employee, regardless of the classification of the job. Hourly salary, executive, janitor, didn't matter. Everyone had to sign it. I did not agree with that. However, you can't win every battle. So that one did not get changed. But here's the thing. What I experienced, and I'm sure other employees did as well in many different companies, is that we didn't know about that employment agreement until after we got in. It was part of our onboarding experience, not part of the offer letter, which had I known or had other people known that, okay, you're going to have to sign an employment agreement and it has a non-compete, a non-solicit, and all that legal jargon that goes above and beyond an offer letter. If you have employee agreements, be courteous to your future employees and let them know up front as part with the offer letter, separate but together, so they can make a very educated decision and vet that all out before they start, not on their first day. And again, personal experience. And so I had to sign it, but not a very good experience to feel that walking in. Background checks and drug screening, if you choose to use them, they are processed post-offer. So you give the job and then it's contingent upon passing the background check and the drug screen. Sometimes companies realize they don't realize they're getting it out of order and they want to run those background checks early and then decide whether they're going to give you an offer. Please don't do that. That is non-compliant and illegal. Credit history checks. This is also post-offer, and it may apply to certain jobs. To me, it makes sense. However, we're going to come back to that topic in a few slides. Maybe you're the director of finance or you're the CEO of the company. You would want to make sure that your top candidate that you're choosing, you give them the offer, that you want to make sure that they're fiscally responsible. To me, that makes sense. However, we're going to see with new proposed law in Michigan, that might become prohibited. We shall see. And I can also see the other side of it, that someone's credit history doesn't really have a bearing on how they could necessarily do the job. So there's shades of opinions and differences there. We shall see. Now, how do you stay compliant with the onboarding? Well, just to talk about a couple things here, the I-9 form, Form I-9, and the Form I-9. It is the #1 most non-compliant form in the onboarding process. And I haven't met an I-9 form that I haven't looked at and said, oh, it needs corrections. And when you have this type of form, you would think so simple, right? Why would there be so many compliance issues? This I-9 form, if you're not familiar with it, is to verify that a person has the right to work in the US. They have their documents in order and that you're filling it out correctly to attest to that. There are fines and penalties for every little check mark that is wrong on an I-9 form, and it adds up by however many I-9s that are wrong. So firstly, learn how to fill it out properly. Secondly, please don't file it in your personnel files. It has dates of birth on there. You cannot put that as part of the performance personnel file. Keep it in a separate binder if you have them physically. Active and terminated employees, separate them, or use E-Verify for it. You may want to conduct an I-9 audit once you learn a little bit more. I've given you some more resources here, especially because, again, new regulations are forthcoming, and this is not proposed. This is for real. During the pandemic, we were allowed to provide remote verification of employee identification, such as driver's license, social security card, passport, birth certificate. Those were some examples on this form. But that stay is now ending. And not only is it ending, you have to retroactively go back and physically examine those documents that you did not get to see except through Zoom or email attachment or fax. How administratively burdensome is that? It is true. August 30th. Any employees that you've hired since March 20th, 2020 through today and onward have to be re-verified and then verify it now in the old-fashioned way physically. Here's a couple solutions. If you don't have someone an employee's in a different state and you don't have an office there with a manager, it doesn't always have to be HR. It could be someone else in the company who's trained on how to do it. If they're not present to be able to do that physical review, you could utilize a notary. You can tell the employee, take the form, get your documents, go to a bank, go to a library. Who do you know who's a notary? And reimbursement for their fees. You could do that. For future or out-of-state remote new hires, again, find yourself a notary or some type of solution to handle that for you. Full details, I give you some links on here to look at. And also the form, to get to the Form I-9, it's on here. It is still an active, valid form, even though it says the expiration date of October 21st, 19, that is the latest form. Typically in these situations, they're always behind on updating these forms, this particular one. So that is, it's still valid. Now, here's the thing. They proposed a rule that would allow alternative procedures for that examination of those documents. So it's still out there. They're considering it. We'll see if they end up going back and reverting to allowing any type of remote verification, but we'll find out. Stay tuned. Now, how do you stay compliant with creating and maintaining updated job descriptions? Well, you might be saying, Elizabeth, I don't have time to write job descriptions. We just have to get going and just start working, or I can't take the time to go back and they're outdated and I know they are. Well, I get it. I know we've all been there in HR, but let's just kind of give some color to this, right? Having a written updated job description provides a roadmap for success in the role, right? It helps to determine from there if it's supposed to be categorized as classified as salaried or hourly. Hugely important. That's the crux of why you want updated job descriptions, to make sure you're properly classifying, hence properly paying your employees. The positives out of that, the employee knows their expectations. They can see, oh, this is what I need to be doing in my role. And then you can hold them accountable and help manage those performance expectations. And it helps with developmental opportunities. Maybe they're going to develop and grow out of that role because they've mastered it and they're ready for more. Or maybe they need some course correction. And this is a roadmap to say, these are the areas that unfortunately you're deficient in and we need to help you along in. That is why updated job descriptions are very important. And have you ever thought about this? Stress. if stress is a significant essential function for a job, and how many of us don't have stressful jobs, right? I joke, but it is true. There are some instances where someone may say, I have an anxiety disorder and I cannot do this job. I have, this is a real case here that I'm familiar with. This employee had PTSD of working with men, but it was a job where they were working a counter in a gym and had to interact with the public and with coworkers. And she was saying, I can't do this because it's just my anxiety and I have PTSD, and all very valid, very, very valid. However, an essential function of the job is interacting with people. Now, just to give you a little more flavor on this, the employer ended up losing that case. Not because it wasn't listed as an essential function, but the second part is they didn't even try to work with the employee in the interactive process to say, well, what can we do here to help accommodate you with your anxiety disorder to be able to do your job? At least pros and cons, is there anything? And they didn't do that step. Had they done that step, they probably would have still ended up saying, oh, it's an essential function of the job. You need to talk to people in person. We can't keep you in your job. I'm sorry, we're going to have to let you go. It was the interactive process that they skipped. So that's why communication is so important. FLSA classification, salaried versus hourly duties test. Well, this is some of the language that determines, can you pay them salary? Can you pay them hourly? And then it would be eligible for overtime for anything over 40, or in California, of course, they've got even more robust overtime laws. So exemption from overtime for executive, administrative, professional, and computer, outside sales. There's all these buckets, right? Generally speaking, the tests also say that their salary must not be less than $684 per week presently. Now, you can include some non-discretionary bonuses and incentive payments, but not more than 10% as part of all of that. But this is what's important to keep in mind. Job titles do not determine exempt status. A very over-the-top example is the director of janitorial services. If they're the person who is pushing the broom and cleaning the rooms and doing janitorial work, that is hourly, no matter if they have a director title or not. So in order for an exemption to apply, you have to meet specific job duties and the salary and all the requirements that are listed. So I'm not going to go into great detail on that. However, we can provide that additional resource separately, or you can do a quick search to see how to help you walk through that. What I really want to dig into now is, how do you classify your folks who work for you? Are they all employees on payroll? Do you have any independent contractors? Now, it's not necessarily non-compliant to have independent contractors work for your company, but have you gone through the checklist to determine if they are really contractors? There is a 20-point checklist that the IRS has put together, and I use it a lot with clients to explain how to properly vet this out. What are some examples of independent contractors versus employee misclassifications? We had one client, which was a retail store. Industry doesn't matter, but it was a retail store, so they had high turnover, seasonal, and they just wanted to try employees before they would, say, yes, you're going to be brought on board. So they paid them all as 1099s. And 1099 employees, the independent contractor status, they don't get taxes taken out of their check. Then it's on them to figure out how to do all their taxes, but there's shades of how is the employer liable for that, for not getting the proper taxes taken out and also paying in that they need to. Another client, again, they also had a transient workforce, and they didn't really have the systems in place to make hiring an easy process, onboarding. So they said, I don't want the headaches of all the forms and then adding to payroll, and then they stop working after a couple of days, and we have to term everything, and or a month later they're on benefits, then we have to unenroll them in benefits, and it was just such a big hassle. They just said, make everyone 1099, independent contractors, solve all your headaches. Well, we did an audit with them, a quick compliance audit, and that was one of the things on the check mark. I said, oh, no, we have to dig into this. Show me your independent contractor agreements and talk to me about these employees that you pay 1099 that don't have an independent contractor agreement. So we went through them, and I noticed in the independent contractor agreements that they had, which were with salespeople, they had words like must follow the employee handbook and all the company policies and all the company equipment and so forth. Those are all things on that 20-point checklist that would clearly show that's an employee, even though you have this little agreement that says you're an independent contractor. Additionally, another one is if you're contracting with the person directly and not with a company name. So he is company XYZ and a salesperson, and he can sell these types of similar products for more than one company. He's his own business, his own salesperson. That is more compliant than contracting with Joe Smith, and Joe Smith only sells products for you and reps you only your company. That's one example. So what do you do? What's the solution here? What I had proposed in this case was, if you don't want the hassle of onboarding, firstly, you can contact Rehmann. We do that all day long, helping with those admin tasks and outsource them. Secondly, you can go to a temp agency and say, okay, we may have found the people, but we don't want the headache and the hassle of all that stuff. Can you just put them on your payroll, temp agency, and then refer them back to us? If they don't work out, we'll just let you know. Please don't send Joe back because he's just not working out, or he's late all the time, or he stopped showing up. And so it's a clean break, and then the temp agency has to deal with all that. Now there's the markup, about 30%, but that's 30% that you didn't have to deal with all that headache. So outsource it to Rehmann or another like third party, temp agency. So there are solutions to fixing these things. And that's what we like to do. We like to fix your non-compliant issues. So the things that fall under how to determine whether they're employees versus independent contractor is behavioral control, financial control, and relationships of parties. I'm not going to go through all of it with you, but there are some documents that you'll be able to go through and get those and see what it is. We'll include those. Behavioral control, meaning that, are you telling them when to show up, where to show up, and are you giving them their equipment to work on, their laptop, a cell phone? Those are all employees. Are they able to invoice you and account for their time? Are they invoicing you for, flat amounts, or are you keeping track of their time with timesheets as employees? And what is that relationship? Do they have the right to work for other like-minded competitors, for instance, or in a similar industry, and they're providing the service not just to your company, but to others? That more is an independent contractor. Or are you saying, you only work for me, you cannot moonlight, you cannot do anything that could contradict it? That you're controlling and showing that there is a definite relationship there of employee-employer. So you definitely want to take a look at your practices for independent contractors versus employees, because again, the DOL, they're looking for this stuff in FLSA claims. This is exactly what they're looking for. And you really don't want to have to pay an independent contractor going 2 years back overtime that you should have been paying, and it's astronomical. Here's another topic that I'd like to touch on. Leaves of absence and accommodations. So we have, my team put together a beautiful workflow of how to manage leaves, and it's too much to put on this screen. Happy to make that resource available. Let's just talk about how these all intersect. ADA, short-term disability, FMLA, personal leaves. How do you navigate all of this? In addition, some states have mandated paid disability leaves. California, New York, and several others here. Well, take heed. This is what I want to give a word of caution. Before you separate employment from someone, make sure that you're assessing any risk. If you're letting them go before they take a leave, while they're on a leave, or after they return, doesn't mean you can't do any of those things, but be very cautious. Talk with an employment attorney, your HR team, be very deliberate about your separations. Utilize that interactive process, as I said. Here's how it works. You have an employee, say they qualify for FMLA. This is not a course on FMLA. There's so much to learn about it, but generally speaking, they've been with you for over a year. Your company has to offer FMLA. You've got 50 more employees in a 75-mile radius, and they've worked over, 1250 hours, so they qualify, okay? So they have to take a medical leave. You give them the FMLA forms, and they might have short-term disability coverage through your company as well. So you give them that claim form. And FMLA runs out after 12 weeks, but say they're recovering from a surgery and they need an extra week or two. So they're like, I know I'm out of FMLA, but I need another week or two. My doctor says that I should be okay by then. What do? If you say, well, I'm sorry, we can't hold your job open that long, this is where you're falling into that gray risk area. Utilize that interactive process, meaning that, okay, well, if it's only a couple weeks, you check back in a couple weeks and give us a new doctor's note saying that you're clear to come back to work, or if you have any work restrictions that we need to accommodate for you. Again, interactive process. Sometimes you might get a note back that says indeterminate, undetermined time of when they can return to work. Well, if the doctor can't determine it, it doesn't mean that you have to hold the job open week after week after week. That is a case where talking with your employment attorney, they would most likely tell you, well, if there's no end date in sight and they're not asking for any accommodations and you're saying, what can we do? We're happy to have you back at work, but how can we work with you? Or you can't be back at work and you don't know when, you can't really work with that, then you could take steps toward unwinding the relationship. So just be very cautious and think about all those angles, because I had another client who we advised, please don't terminate them when they return from their medical leave. They had performance issues. Everything was lining up where, yes, they should have terminated them. And they were rightly on the right path to do so. However, they chose to terminate the person on the day they returned from their medical leave. Now we're dealing with a lawsuit. So please just be careful. Another note that I would like to have you take as a takeaway is having a no-fault attendance policy. I see this often in manufacturing environments, and you think, well, it doesn't matter why you're late or why you didn't show up. No fault is no fault. You could have had a sick child at home. You could have gotten in a car accident. You could have overslept. No fault doesn't matter. Some of them have point systems on their points for attendance. And once you get to a certain number, you're terminated. Well, be careful of that, because you may create unintended consequences, such as what we just talked about. What if one or two of the times that they missed work or were late was because of something to do with a protected leave? Could be intermittent FMLA, where they had a flare-up, a medical flare-up that they couldn't come into work, and so forth. There's doctor's notes and so forth that can help cover that. But again, just be careful that you could accidentally back yourself into a corner. And if you go zero tolerance, you've got racked up all these points and you didn't pay attention that you should have been applying those doctor notes to take off those points and not count against them. That's where you can run into issues. And again, I'll have a resource for you that shows how does this all work. For instance, personal leave. Some companies choose to offer personal leaves if they don't qualify for FMLA or it goes beyond FMLA. How does that all work together and overlap? Because another word I haven't said yet is concurrent. FMLA and short-term disability, if you qualify for both together, run concurrently. You don't put one and then another and then another. So we have this chart that really does help you. So let's touch on benefits here really quickly. If you do benefits for your company, keep tight controls, audit your carrier bills. I know this sounds silly, but I have another client who they were not paying close attention. People were not enrolled in their benefits. People were not terminated. So they're paying for people who never got their COBRA letter. And that's a whole other compliance issue with their COBRA rights. I recommend outsourcing your COBRA to a third party. Often your benefits broker can recommend it, or sometimes they do it. Rehmann does not do that. We do not want that. COBRA is its own little special set of laws and legislation there. Know if you're subject to ACA, average of 50 employees in a given year, average. Not you don't have 50 employees by the end of the year. What was your average that year? We've had clients who say, what's this letter from the IRS that says I owe $200,000 for not reporting on ACA in prior years? I never had that many employees. Well, either the IRS thought you did, or they didn't fully, they're seeing all these W-2s, right? If you have a higher turnover, you've got more than 50 employees in a given year, just not all at once, they may trigger an audit to say, oh, no, you did, and you should have gone through the proper filing for under ACA. So be mindful of that. Again, engage with your benefits broker on that. We can help as well. Make sure you hold your open enrollment annually so your employees can choose to make changes or not. I've had clients who, well, we just tell them, if you don't want to make any changes, then okay, it's just passive, Well, it's a whole other compliance issue that they're missing things, and just offer it. Work with your broker. Please don't promise employees early entry into your healthcare plan. You're going to disqualify your plan. If you need to for a new hire, tell them as part of their offer letter, you're going to pay them a signing bonus, and then they can take that signing bonus and pay for their former employer's COBRA until they start on yours. And please, please make sure COBRA is offered if you are subject to it. Do not leave your termed employees active if you're letting them go, for instance, on a severance plan, severance agreement. You can go ahead and have them pay for those deductions out of their paycheck at their current amounts if they opted for the severance plan, but trigger their COBRA notice through your benefits broker and third party right when that happens, and they'll get the COBRA letter, they elect it, but then they just pay normal until they're done with severance. And then if they don't want to continue on paying COBRA directly, then they just let it lapse. All these little things, I hope that you are, please revisit. These are super important compliance issues. OSHA. Now, I've had clients say, what is OSHA? What's an OSHA 300 log? It's a summary of workplace injuries and illnesses from the prior year that you need to post physically, conspicuously on site at every location for that location in your company, February 1st through the end of April. And then you can take it down, but keep it and file it away. There's also reporting that you have to do to the state. It's not isolated just in manufacturing companies, although it's the most impacted by workforce injuries. What I recommend is, if you don't know what this is, educate yourself. Reach out to your Rehmann advisor. We can quickly get you up and running on this. I did this with another client, taught them how to do it. Now they know. It's not hard, but you got to keep it going. Set up a safety program with your company for same-day reporting to mitigate your workers' compensation costs from going up and keeping your employees safe. Safety first. How do you stay compliant with separations? Whether it's voluntary or involuntary, they can come with their own unique set of complexities and risks to mitigate. So know your risks. Be candid and clear in the performance issues, documenting them. Provide training and coaching when you are working through your corrective action plan or progressive discipline, if you have that. You might want to offer a severance agreement if necessary, because it has some teeth in there. Right now, it still has non-compete being allowed and so forth. A non-solicit, disparagement, if you feel it's necessary to avoid, they may sue. A person can sue for any reason, for anything, anytime, anyone. But in some cases, you may want to consider that and work with an employment attorney on that. And Raymond, we have helped many clients in that area. Handle your unemployment claims responsibly. If someone is duly due their unemployment, then don't deny it. But in other cases, contest it if you need to. Be alert to employees quitting under what's known as constructive termination. They felt that things were so bad or they couldn't remedy their situation. No one was listening at work, and so they just gave up and had to quit. They had no other alternative. And they could be eligible for unemployment and a lawsuit as well, might be warranted. Always keep an individual's dignity at the top of your mind because you have their livelihoods in their hands. You know, every termination I've done, I always think about this isn't just the employee, this is their family, this is their friends, this is their coworkers, and how many people are affected by it. One quick story. I had told a manager, you know, kind of walk through this termination. And I always said, you know, in some cases, they may want to say goodbye to their team or their coworkers. Use your best judgment, and you have to be discerning. But you let them know, would you like to talk to anyone? Because you're escorting them out of the business, out of the company, right? And this manager said, the employee asked, can I please go say goodbye to my team? And the manager said, oh, no, that's just going to be very disruptive. And you're crying. And I just don't want to put you in the situation to look at your team and you're all crying and emotional. That stripped that person of their dignity to the point where they sued the company, and we had to work through a settlement. And you know, it didn't go to trial or anything like that. But what they told me was they felt like they were a non-person at that point, that they were not allowed to talk to their team and say goodbye. That's the human face behind this that I want to share. Now, there's several new laws we're going to wrap up with here in the last 12 minutes that I want to touch on. Proposed laws that are very employee friendly in Michigan. So these are all of them here. We're going to bang through these. Productive scheduling. Can you imagine in an hourly hospitality, retail, food service industry, being told that you have to give 1 to 2 weeks advance notice to your employees that their schedules may be changing? That's pretty strict. What happens? People are already calling off and not showing up as it is. And now this law proposed is going to say you need to make sure you give enough advance notice. And if you don't, well, the employee can decline without retaliation. And if you don't, and the employer has to pay the employee a premium for working, which is time and a half. And it also prohibits scheduling employees to close one night and open the next morning for, you know, those close in time shifts. Now, several states have already enacted this law. Many cities within the states that are listed here, it's actually down to the city. And several more states have proposed similar law. And some states have even said, we're banning this type of law. It's fascinating. So this is a hot topic. We want to make sure that you're aware of this. It's on the horizon. We'll see whether or not this happens in Michigan. This one, I feel for employers. It's already hard enough to hire people, let alone to have such, you know, when it's up and down in scheduling. It's hard. Another potential law is banning credit history checks. Now, again, this may make sense if you shouldn't always factor in credit for how someone can do their job. However, on the other side of that, financial people, financial acumen is part of it, as well as CEOs. We'll see, but there are other states who have already passed this. So we'll see. Non-compete agreements in 2 areas. The FTC has issued a proposed rule to prohibit employers from enforcing non-competes against former employees, contractors, and other workers. Now in Michigan, if this happens, then it's gonna, what they specifically call out is the low wage employee, someone who receives less than 138% of the federal poverty line for a family of 3. This current year for 23, it's just over 34,000. So, I mean, it makes sense. As I said before, some jobs, why would you put a non-compete on it if there's nothing proprietary or highly intellectual? So this one, I'm on the fence of I get it. This is logical, but be aware of it if it happens. Payment of Wages and Fringe Benefits Act proposed changes here. If you misclassify an employee, they really should have been an employee, and you misclassify them as an independent contractor, they're stating that they want it to become a standalone violation. What does this mean? For every single infraction, $10,000 at the most per infraction. And you may have to pay all the wages that they were due, fringe benefits. So what would that mean? Overtime for the independent contractor that they didn't get paid, fringe benefits if there were bonuses, if there was anything with health insurance that they didn't get eligibility for, and a penalty of 100% of the wages and benefits due to them. Ouch. And well, the company didn't pay any of the federal taxes and the Medicare payments for that month. They were ICs, right? And then exemplary damages up to 3 times the amount of the wage and benefits. So, and this is if there's flagrant repeat violations. So they keep making it tougher. Pay transparency. Under this particular proposed law, it would require employers to provide employees with 30 days of their request with their wage information. How much do people in my job classification make 3 years back? And they wouldn't give names, but you'd have to provide the sex, the seniority of these employees. And so pretty much you can kind of figure out who possibly it could be making what wages. And you would have to also include bonus and overtime, any form of compensation. Now that feeds into the Bullard-Plawecki Act that's been proposed for an amendment. Now this act here, to summarize it, an employee has the right to request to see their personnel file that you have in HR, that you have on them. What this means is now it would require pay transparency to applicants and current employees. It would mean that on the job description for the applicants, it shows the wage spread of what it is, the salary information, and also the census of information. Who is it, or not who is it, but the census information with the names removed so they can see how other people are paid. Other states have similar laws that are listed here. So this one makes me a little nervous because then it goes into pay equity. If you already are concerned that you may not be paying your minorities and your men and women equitably, if you're already concerned about that, get this on your radar now. We're doing comp studies for clients that also include pay equity, so we can help close those gaps so you don't have such a bind if and when this gets amended. I do believe there's going to be more and more pay transparency laws enacted. The Whistleblowers Protection Act has some changes. Now, what this means, some steep fines here. If this happens, independent contractors and prospective employees could assert claims. And what does this mean? That it would prohibit, it would protect activity that they could participate in investigations and hearings and in courts and so forth. This bill would also significantly increase civil fines for a violation of the act from $500 to $10,000 for each violation. It creates a bounty. This blows my mind. It creates a bounty reward. So an employee who reports a violation, if it turns out, yes, you were right, thank you for letting us know, Mr. Whistleblower, here's 30% of the money that we recovered. That is incredible. I don't know what to say if this one passes, but that's what's in there. That's what's proposed. The DOL has proposed the independent contractor review rule. So this is going to be a 6-step economic realities test. Basically, what this means is they want to make it harder to classify someone as an independent contractor, and it also may allow unions to more effectively organized. So here's the 6 areas. Again, not to get deeply into it, but is it a short-term or long-term relationship? Are they really part of the company, or are they ancillary? How much of the worker's own investment goes into the equipment and being on site? How much control do they have, or the employer have, over the person's work? And does the worker have opportunities for profit and loss? Meaning, are they running their own business rather than, it's up to the employer? And then the amount of skill and oversight and, management and decision-making. So be on the lookout for that. Coming into the home stretch here, we have 4 minutes left. We have resources for you. We have a compliance chart that we've put together by employee headcount, and it's too much to put on this screen. But it breaks it down to, if you have so many employees, and it steps it through it for the different various laws, and then the links for more information. We'll be happy to provide that to you. We can also assess state by state laws for you. If you are a multi-state employer, have remote employees or actual physical locations, we have clients in all of the above combinations. And on my team, we have 13 HR professionals on my team, and we have anywhere from at least 10 years experience per person all the way to 30 plus. And so we are very well steeped in state laws, all of them. Please send us an email to hrsolutions@rehmann.com to request this complimentary compliance review. We can tell you within 30 minutes where you stand compliance-wise by walking through this compliance chart with you. And then we're happy to walk you through that and then send your results to you so you know. And then you'll have a game plan of what you need to address and mitigate to close those gaps. And we're happy to help you with that, or at least give you these resources if you want to take a swing at that yourself. In addition, the list that I showed you for the EEO guidelines for interviewing questions, I will send you the comprehensive list for that. It's like 3 pages long. And doesn't have the interview questions. It's what you can ask and what you can't ask. We also can help clients write interview questions and recruit and so forth, but this is just for your edification here. And that FMLA flowchart, I call it FMLA, but really it's any type of leave, short-term disability, and how they all run concurrently and dovetail, and what should you do when in each instance. So it's a nice little checklist to go through. Thank you, everyone, for spending this hour with us. I am so passionate about HR and mitigating risk for employers, as well as protecting the rights of employees. We're super pleased that we were able to bring these resources to you, and we're here for you. Please feel to reach out. And Rena, I'll turn it back to you.
Thank you so much, Elizabeth. This presentation was jam-packed with a lot of valuable information. I've been seeing all the questions come through the chat, and just due to timing, we're not able to get to all of those questions, but we will be following up with you after this webinar to make sure that we get those answered for you. As Elizabeth said, if you guys are interested in receiving access to the compliance chart, the FMLA flow chart, the EEO guidelines, or if you have any additional questions, please use the hrsolutions@rehmann.com email to send a note to us, and we will give you access to those. So once again, that's hrsolutions@rehmann.com. And we'll be sure to get in touch with you with those resources. The recording and this presentation will be available. We are going to send you guys a follow-up email. So once again, check your inbox in the next 24 to 48 hours, and we'll have this available to you, as well as that email address to gain access to those resources. And as mentioned in the beginning, this webinar, it does qualify for those SHRM and HRCI credits. So now we're sharing the activity IDs for those credits. So please take note of those. But this concludes our time together. We really thank you for participating and spending your morning with us. Thank you, Elizabeth, for sharing your knowledge. And we just appreciate you and everything that you guys are doing in the HR world. Have a great rest of your week.